Okay, so now you know why I kept using all those jury size study examples in the scientific methods section of the class after reading these materials on jury size. So you'll remember, me using that example a lot, coming up with ways to do studies, for example, on the effects of having different numbers of jurors. So even though you might not have thought that the Supreme Court's jury size and unanimity jurisprudence would be that interesting, I think it really is. Certainly in relation to the incorporation of certain of the amendments in the Bill of Rights and making those applicable to the states. So hopefully you're covering that in your Crim Pro classes in detail. But here's the text of the Sixth Amendment. We were familiar with this one. We've gone through it already. But the part that I have highlighted here is in a criminal prosecution, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. So we talked about this in the context of jury death qualification for death penalty cases. But here we're talking about what size jury is required to comport with the Sixth Amendment. So remember, the first 10 amendments to the Constitution were added after the Constitution was ratified to put certain protections in place to make sure this new federal government that was being formed wouldn't usurp the rights of the people that they had fought so hard for in the Revolutionary War. And as I've mentioned in class before, those first 10 amendments, including this one, were known as the Bill of Rights, and they were originally written to apply only to the federal government and not the states. So either in Con Law or in Crim Pro, or hopefully both, you should have looked in depth at the Supreme Court's struggle to decide whether each of these rights set forth in the Bill of Rights should be incorporated against the states. In other words, whether the states had to honor all those rights just like the federal government was required to. So for purposes of this video lecture, I'm skipping my in-depth explanation of the incorporation process in general, and I'm also skipping most of the slides on the 1968 Duncan case, but that is where the Supreme Court decided that the Sixth Amendment jury trial right should apply to the states. Just to do sort of a quick and dirty version, the Duncan opinion left open the issue of whether the federal requirement of 12-member juries should ever apply to the states. And in fact, some justices expressed concerns that if you were to burden the states with putting together 12-person juries, it might be asking too much of the states. A couple of justices, in fact, for example, Justice Harlan, were really worried that in the future, juries of less than 12 might be allowed. And those justices who had that concerns considered that at least the federal right to a unanimous verdict from a jury of 12 members was fundamental to the justice system. So that's just sort of a little background on what happened prior to the Williams case in your book. All right, so just to be clear, you're not going to be required to know any of the issues about the Duncan case or incorporation. I just wanted you to have that background. All right, so now we're getting to the material from the book. So just 2 years after that Duncan case, in 1970, Justice Harlan's fears that I talked about were in fact realized, right, when the court decided the Williams versus Florida case. That's on page 261 in our book. So the court here upheld a Florida statute allowing a 6-person jury in a non-capital case, and in fact went on to basically conclude that the 12-person jury, even in the federal system, wasn't fundamental, but instead had just been an incidental practice that had developed over time. So the basic form of the analysis of the court is the same in the Williams case and in the 1973 Callgrove case in your book on page 263. So the Callgrove case is actually about whether the 7th Amendment requires 12-person juries in civil cases. So in Callgrove, we had a little bit more divided court, but still the court upheld a Montana rule that civil cases could be tried to 6-person juries. So the quote that I have on the slide is from page 264 of the book. The court says, since Williams, right, the Williams case in 1970, much has been written about the 6-member jury, but nothing that persuades us to depart from the conclusion reached in Williams. So to see what the court is talking about here in terms of the much has been written, you have to look at the long footnote 15 there on page 264. So this footnote references research studies that have been published in that 3-year period between Williams and Callgrove from 70 to 73. So all of those studies purported to be comparing 6 and 12-member juries to see whether there in fact were differences. And we'll talk about those studies in a minute. But in both cases, first the court looks at the text of the Constitution and related historical documents to see if it can figure out the intent of the framers on this jury size issue. And then after concluding that the framers intended the jury to just serve a certain function rather than to be a certain number, by essentially saying this 12-member jury was a historical accident, suggesting maybe in the past the number 12 had religious or mystical roots, the court then embarks off on its analysis of, well, what are the functions of juries then that the framers were interested in? And social science was considered there by the court in determining whether the function of the jury was undermined by a reduction in jury size from 12 to 6. So first of all, that begs the question, well, what kinds of things did the court think were important in terms of the function of juries, set forth in Williams and reiterated in Callgrove? Well, first, juries were in place to prevent oppression by the government by utilizing the quote-unquote common sense judgment of a group of laymen to decide legal issues. Secondly, the court talks about the virtues of community participation and shared responsibility that arise from a group determination of guilt. And next, the court agrees that juries, quote-unquote, should probably be large enough to promote group deliberations, should be free from outside attempts at intimidation, and should provide a fair possibility for obtaining a representative cross-section of the community. Now, even though the court throws the social science in that footnote and mentioned that none of it was persuasive enough to change its mind, which makes us think that the court actually did consider the science, it's really too generous here to say that the court actually considered the social science evidence well in either Williams or Callgrove. And we see this brilliantly laid out in Michael Sachs's 1974 article on page 265. So because I think this is such a great critique of the court's use of science, and because I think there's some really good methodological analysis, the kind of thing I would ask you to do on an exam, I want to go over this article in detail. So Sachs starts by pointing out the fact that the court did seem to be posing empirical questions for itself to try to answer about the differences between 6 and 12-member juries with regard to, first, providing a representative cross-section of society, and with regard to, second, being reliable and accurate. And we remember, reliable here meaning, would juries generally agree on outcomes in similar cases with similar facts? And accurate meaning, would juries reach the arguably correct outcome? Third, would 6 and 12-member juries provide adequately for initial vote jury members' ability to resist majority pressure? And next, would they provide equal amounts of deliberation? And would the likelihood of conviction in criminal cases be about the same? Those are the questions the court seems to be posing for itself when it's talking in the opinion. But then Sachs goes on to criticize the court's process in coming up with answers to its own questions. That's Michael Sachs, actually, there on the right, in the right-hand photo. As you can see, he's a good friend of ours along with the Parks. But I just want to point out that his work was really ahead of its time in the science and law intersection arena, just like John Monahan. Again, Michael Sachs's article written in 1974, but still very vibrant and relevant today. All right, in the Williams case on page 262, the court says, what few experiments have occurred, usually in the civil area, indicate that there is no discernible difference between the results reached by the two different sized juries. And the court cites there to footnote 48. And Sachs on page 265 absolutely shreds the references in that footnote. So here's what he says. One reference consisted of an unsupported assertion that there would be no differences. 3 were reports of haphazard observations by officials in courts using 6-member juries who said, hey, we don't see any differences. Another was a report that a jurisdiction was just trying out 6-member juries, and the 6th that the court references in footnote 48 was just an article on the economic advantages to be expected from reduced jury size. So he goes on to say, not one of the references even begin to address competently the empirical questions the court posed for itself. And then Sachs starts in on the court's misuse of the studies it lists in footnote 49. So going back to the Williams case, the court says, citing to footnote 49, that, quote unquote, neither currently available evidence nor theory suggests that the 12-man jury is necessarily more advantageous of the defendant than a jury composed of fewer numbers. Here, Sachs discusses the studies in this footnote and basically says the court completely missed the boat in analyzing those. So in which two major areas did the studies here provide evidence that 6-person juries would in fact not be equivalent in function to 12-person juries? Well, first is the issue of whether a 6-person jury adequately protects a minority's ability to defend his or her view. Now, when we say minority juror here, we mean, for example, a juror who in an initial vote of guilty or not guilty votes differently from the other jurors. I talked about this a little bit in class. So Michael Sachs points out that not only the studies the court cited, but also a large additional body of social science research shows clearly that, for example, there's a big difference between being in the minority of a 12-person jury vote of 10-2, where you are one of the 2 people voting to acquit. Big difference between that and being in the minority of a 6-person jury vote of 5-1, even though they both represent 83% to 17% splits, because the research is just uniform in finding that having an ally makes a huge difference with human beings in whether the minority voter is going to change his or her vote due to pressure to conform. And there are some great videos online of the research illustrating this idea, in particular the Ash experiment. So I encourage everybody to go to the YouTube link on the slide. The study that's depicted there is a real study. It's actually entertaining, as well as, it does a great job of illustrating the idea of pressure to conform and what that pressure can do to a person's confidence in his or her own even visual perceptions. Next, Sachs points out that the studies referenced by the court covering the effect of jury size on obtaining a fair cross-section of the community illustrate, in fact, that both theoretical statistical predictions and experimental findings, both, show that 12-member juries are much more likely to include one or more members of the minority. And here I mean the minority of the population, say a racial or ethnic minority. And you can see those statistics in Sachs' article on page 266. Then Sachs moves on to talk about the 4 studies that were conducted in the years between Williams and Colgrove from 1970 to 1973, which the court, in fact, considered in Colgrove as supposedly supporting their proposition that 6-member juries were equivalent. And what problem did Sachs have with all 4 of those studies? Methodology. Methodology was the problem he had. So here are some great quotes from the book. An empirical finding is only as good as the methods used to find it. Method is the overlooked but more important term in the phrase scientific method. So, studies using poor methods tell you nothing, right? But they can seriously mislead because their findings still might properly be called empirical. They're empirical findings. They're just bad empirical findings. So the 4 empirical studies cited in Colgrove, because of their faulty methods, actually said a lot less than the court thought they were saying. And again, this is 19 years before Daubert that Michael Sachs wrote this article. So let's go through quickly all 4 studies the court used in Callgrove. And again, these were civil jury studies. All right, so study number 1 and number 2 compared the behavior of 6-member and 12-member civil juries where litigants could choose which jury size would hear their case. And the court basically said, oh, this study showed no difference in outcomes that exceeded chance levels. But if you look more closely, you see that, for example, in one of the studies, 12-member juries in fact deliberated longer, awarded 3 times as many damages, and required twice as much trial time. So that actually might sound pretty different to most of us. Also, big problems with these 2 studies boiled down to one word, and that is confounds. So attorneys actually ended up choosing 12-member juries for cases involving high damages or more complex issues. So of course that also helps account for the longer trials and higher rewards, which in fact was confirmed by looking at pretrial settlements in cases that were scheduled for 12-member juries. There were more settlements as well for higher amounts. So again, this kind of thing in methodology lingo is called a confound. We went over that in class. So the researchers here figured out that it was probably complexity of the cases and not jury size that created any differences. But what is Sachs's additional criticism? Well, 2 problems can happen. Confounds like complexity and amount of damages can create differences that are not due to the variable of interest here, jury size, but also confounds might in fact mask differences that are in fact caused by the variables of interest. So Michael Sachs really astutely says in his article, in these studies, when the researchers saw a difference they didn't like, they explained it away by pointing to the confound. When they saw a non-difference they did like, they made believe the confound wasn't there. Given the procedures by which the data were collected and analyzed, one is simply unable to know what effect, if any, jury size did have. Next, study number 3 compared a sample of 12-member jury decisions with 6-member jury decisions after a statutorily mandated reduction of jury size from 12 to 6. The researchers again found, oh, no difference in the direction of verdicts. They didn't even look here at damage awards, or it's unclear if they did. So that sounds good so far, right? You have the same jurisdiction in a before and after comparison, no attorney choice here to get in the way of good results. But what are Sachs's criticisms here? Well, the criticism is that there was a mediation board simultaneously created to settle negligence cases, which make up a big percentage of the cases. So Michael Sachs suggests that, in fact, more expensive and complex cases were routed to the mediation board by attorneys rather than trusting them to 6-person juries. So the results here are also really suspect. And lastly, study number 4, here we actually had a true experiment using mock juries and assuring that the only variable that changed in the study was the variable of interest. So this strength of being able to control study variables, again, has potential downsides, starting with the fact that you're using mock juries versus real juries. But Sachs basically addresses that issue and says, look, laboratory studies are virtually never contradicted, in fact, by real-world studies of the same phenomenon. So the details of this study are college undergrads. They formed 8 12-member juries and 8 6-member juries, and all of them watched a videotaped civil trial, found no differences in verdicts. Wow, that sounds really good so far, but big problems, as you saw in the reading. I mean, a couple of little problems, college undergrads versus adult jurors. Again, so you might have some external validity issues, but not a huge problem there. Number 2, sample size was probably too small, according to Sachs. I mean, with a too small sample size, we know differences might not show up. So for example, you had a sample size of 16 here altogether, right? That's only going to actually detect statistically significant differences between proportions of verdicts if the difference is 25% or greater. So you actually need a huge difference to detect a difference when you have that small sample size. So that's a more substantial problem. But the really fatal flaw in this study is the last one. The trial they used on the videotape was so heavily weighted to the defendant that no jury verdicts, in fact, favored the plaintiff at all. Okay. Lastly, we're going to talk about the Ballou versus Georgia case in 1978. So here we're still in the Burger Court era, even though future Chief Justice Rehnquist has joined the court. So at issue here is the movie Behind the Green Door. This is a misdemeanor obscenity case, and Fulton County, Georgia was trying their misdemeanor cases to juries of 5 people. So as you saw, Ballou challenged his conviction in part on the ground that a 5-person jury violated his Sixth Amendment right to trial by jury. And here, the court's decision, in fact, was unanimous that a jury of 5 violates the 6th and 14th Amendments. Unanimous, but with these 3 curmudgeons over here, Powell, Berger, and Rehnquist on the right. And they had some pretty ignorant statements in their concurring opinions, including Powell's numerology statement, sort of disparaging social science and the study of numbers and such. So in this case, Blackmun wrote the opinion, probably the closest thing you could get to a science guy on the Supreme Court. He also wrote the Daubert decision and the Roe v. Wade decision, you'll remember. But the important thing that I really want you to remember about this case is right here. Was there anything striking about Blackmun's detailed analysis of all the social science here? Well, if you look at it carefully, it almost exclusively compared 12-member juries to 6-member juries, finding over and over and over that 6-member juries fall short of 12. So it's really interesting to look at Blackmun basically saying, oh, you can't have juries of 5, and then citing all this powerful science that actually shows that 6-member juries aren't okay either. So the question is, well, was he inviting another challenge in the future? Maybe he thought that in the court in 1978, he might be able to get together at least 5 votes for overturning that Williams-Callgrove rule. But it's unclear whether that would have been the case, because as you saw, there's an amicus brief excerpted in your book with all the social scientists basically writing to the court, urging them to grant cert in the Gonzalez case, talking about how messed up the jurisprudence is on here, essentially pointing out, like, look, go back, court, and read the Ballou versus Georgia case where you said 5-member juries weren't as good as 6. But in fact, all that powerful social science evidence really indicated that 6-member juries aren't as good as 12. And all these social scientists were really encouraging the court to grant cert in the case. But in fact, they did not grant cert in the case. And so that was sort of the end of the issue, unfortunately. All right, that's the end of this video lecture. Thank you.